Sullivan. I'm a Florida licensed attorney practicing family law and specializing in domestic and intimate partner violence cases. One big question that I have gotten a lot throughout my practice has been related to stay-at-home moms and stay-at-home parents and what their rights are in family court. This is going to be a multi-part video series addressing a lot of different legal issues affecting stay-at-home moms and stay-at-home parents. So please follow and subscribe and stay tuned for more. The first issue that I will start with is usually the biggest issue or concern for stay-at-home moms and stay-at-home parents in family court, which is custody. In Florida, the term custody is divided in family court into two different concepts. There is parental responsibility, which is decision-making authority over the children, and there is time sharing, which is actual overnights and visitation with the children. First, I'm going to talk about what your rights are as a stay-at-home parent before anything is filed with the courts and there's any kind of order related to custody. In Florida, if you are married and you have children that are born of the marriage, then you both have what's called equal parental rights unless and until some kind of custody order is entered that says differently, which would require a case being filed. If you are not married, but you are the mother and the father is on the birth certificate and you are not contesting paternity, then under Florida law, technically you do have still equal parental rights. As of July of 2023, the Florida statutes changed to make it much easier for biological fathers who are not married to the mother to have equal parental rights. And so there used to be this concept of a superior right to custody that unwed mothers would have over the children unless and until paternity was legally established in court. Now it's not quite as difficult of a hurdle to overcome for unwed fathers to have legal parental rights based on their biological paternity. Now, once a court case is filed involving custody, then you have a legal standard that will apply to any decisions the court makes about time sharing and parental responsibility. And that legal standard is the best interest of the child. In order to assist the courts in making the determination of what is in the children's best interest, the Florida statute lays out about 20 factors the court has to consider. I'm not going to go through each one of them. You can Google the factors and read through them on your own. I will list the Florida statute site in the video. Some of the big ones include any domestic violence, child abuse, substance abuse, mental health concerns affecting the children, physical inabilities to care for the children, and then there's other factors related to things like co-parenting, the parents' ability to work together, to adopt a unified front when parenting the children, to be respectful of the needs of the children and put those needs over their issues with the other parent or their own needs, things like that. Technically, the court can take the child or children's preference into consideration, but that's a little bit of a complicated process. That's only if the court actually speaks to the children or admits some sort of child hearsay under a lot of specific exceptions. So unless the court actually has the opinion of the child, it cannot consider the child or children's preference. And if it is going to consider the child or children's preference, it cannot just do what the child wants. It is considering that factor in one of all the considerations the court has to make. Today, the court will include these findings in what's called a final judgment at the end of the case, will generally be to list out each factor and to determine whether that factor weighs in favor of the mother, in favor of the father, it is neutral, or it is not applicable. And under that weight decision, the court should list the facts that were presented at trial that support that finding. Another legal change that was made in July of 2023 is what's called a presumption related to custody. Now, a presumption is sort of like a starting assumption that the court will make to begin with, absent evidence to the contrary. The presumption in Florida related to custody is that 50-50 time sharing and shared parental responsibility is in the best interest of the children. That presumption is what we call rebuttable, which means it can be overcome. It just is a higher evidentiary burden to overcome that presumption. If a parent wants more than 50% or wants to limit the other parent's time or decision-making in any way, they will have the burden of proving by clear and convincing evidence that 50-50 and or shared parental responsibility would be a detriment to the children. And detriment is defined generally as actual harm. It cannot be something that may happen in the future. It has to be tied to facts that exist at this time. It cannot be speculative harm. Touching on parental responsibility a little bit more in depth, shared parental responsibility is the default presumption, which means that the parents have to confer about any major decisions regarding the child or children and have to come to an agreement on those decisions. There are two other options. The more extreme other option is called sole parental responsibility, and that would allow a parent who has sole parental responsibility to make all the decisions about the child without having to consult with the other parent or get their agreement. There is a somewhat middle ground. For sole parental responsibility, you do have to prove that detriment factor. Without detriment, you can ask for shared parental responsibility with ultimate decision-making authority. That ultimate say has to be over very specific areas. So I usually ask for medical and educational issues because it casts a pretty broad net, but is still specific. The reason for the need for specific areas is that giving a parent blanket veto power, basically, which would be ultimate decision-making authority over everything, is akin to giving them sole parental responsibility without them having to meet the burden of showing any sort of detriment. As far as the time-sharing schedule, the 50-50 logistics can be up to the parents. If they are in agreement, the parents can work out a schedule that works best for them. I have seen week on, week off. I have seen what we call 2-2-3, which is one parent gets 2 nights, the other parent gets 2 nights, and then they alternate weekends. I have seen a wide variety of things. There is something called a long distance parenting plan, depending on the distance between the parents, where basically if it's 50-50, one parent would get the children during the school year, and the other parent would have most, if not all, of the breaks, including the summer. If you have gotten to the point of proving detriment and you're asking for more than 50%, you can ask for a wide variety of things. You can ask for a 60-40, 70-30. You can ask to have 100% of the overnights, and 100% of the overnights does still allow the court to give the other parent daytime visitation. It wouldn't count as any sort of overnights, but you can ask for a parent to have daytime visitation under whatever parameters you can prove are in the children's best interest, including supervision, no traveling with the children. There are a lot of things that you can ask for once you overcome that hurdle of proving detriment, if that is something that is needed to protect the children's best interest. The other big issue that comes up related to custody is relocation, but that is quite a big topic to cover, so I will cover relocation as it relates to custody in the next video. Stay tuned for more.